Many students had questions about the public function test, and because of that, I'm going to go ahead and review this slide on the public function test so you can understand why it exists. Probably the biggest confusion is why this test was even created. Well, this has to do with the Equal Protection Clause. If you recall, looking at the Equal Protection Clause, the first two words is no state. So no state shall deny to any person equal protection before the laws. So what consists of a state action? That's what you have to ask yourself to see if this equal protection clause will apply. So if you look at state entities such as cities, counties, which would include your police officers, firefighters, even public universities like University of Cal, University of California, Los Angeles, UCLA. These are all public funded universities that are all engaged in state action since they're funded by the state. Well, police officers, firefighters, universities, cities, counties, they cannot discriminate based on race, because if they did, that would be in violation of the Equal Protection Clause. But the question is, what about private citizens who aren't state agents? How about someone who owns a restaurant or a theater or a hotel? These people are not owned or controlled or considered state agents. Therefore, the Equal Protection Clause does not apply to them. Therefore, they can discriminate as long as their own state doesn't try to prevent them from discriminating. This is why this section is so confusing. Today, we don't often see too many states that will allow racial discrimination to exist. Why is it today that we don't see racial discrimination not being enforced? Because of the Civil Rights Act of 1964. Not only does the federal government try to enforce and prosecute people that are engaged in discrimination, they being Congress, has also tied federal funding to the states, telling them you will only receive this money if you enforce anti-discriminatory policies. So today, we don't see a lot of states not enforcing racial discriminatory policies. In other words, trying to prosecute people that discriminate. And if you notice, a lot of these cases that are listed here, they're in the 40s, 50s, 60s, and early 70s. The Civil Rights Act will be heavily enforced financially by the Congress by tying and placing restrictions on grants to the states after the 70s and 80s. So, a lot of these cases, as I mentioned, are based on the 40s, 50s, 60s, and early 70s. So why were these court cases important? Because the Supreme Court was trying to explain the Equal Protection Clause only applies to state action. If it's a private citizen, then the Equal Protection Clause does not restrict their behavior. Only the states can try to restrict their behavior. So let's look at the first case I have here, dealing with Marsh versus Alabama. Here you had a Jehovah's Witness that got arrested and was convicted for criminally trespassing in a company-owned town. She argued she was being discriminated against, not because of her race, but because of her religion, and therefore this violated her fundamental First Amendment rights. Of course, the street that she was arrested for trespassing was a company-owned town. This is in Alabama, so it was a company-owned town, she was, and so the argument was that since it's a company-owned town, then this is being done by a private group. State said she was trespassing on their street, therefore she should be allowed to be convicted for trespassing. Well, the Supreme Court said, look, even though the street is privately owned, it still requires public access. And since it requires public access, and that's something that is enforced by the state government, therefore, even streets in a company-owned town are basically owned and can be controlled by the public because it needs to be provided public access, and therefore state action is involved. Therefore, her right, her First Amendment right in this case, since she claimed she was being discriminated against, was outweighed the company that tried to have her convicted. So, what's the point here? She was being discriminated on a privately owned street. However, the Supreme Court said that that street, even though it's privately owned, serves a public function. Therefore, this does include state action. And therefore, since state action is being considered, her freedom of religion outweighs any other property protection that the company might claim. So that's Marsh versus Alabama. So in other words, a company-owned street still serves a state action, a public function, because it provides public access to transportation. All right, Smith versus Allwright. This case has to do with primaries. Now remember, primaries are held between February and June, and what they determine is who will appear in the general election. Well, a lot of the southern states required that you had to be white in order to vote in the primaries. So these are what you call all-white primaries. So who couldn't vote? Blacks. Of course, what did the southern states say? Well, black Americans, you can vote in the general election. However, by that time, guess what's already been chosen? You're going to have a white bigoted Democrat and a white bigoted Republican. They're going to be chosen by the white bigots in the southern states in their primaries. So what kind of a choice would that be for black Americans trying to vote in the general election in November? So the Supreme Court said, look, even though primaries are technically party functions of the political party to determine who their candidate will be in the general election, it still serves a state function because the states are the ones that are responsible for running the primaries. Since they're running the primaries, it serves as a state function, and therefore the state cannot discriminate, and they must allow blacks to vote in those primaries. Or in short, as I like to say, in Smith versus Allwright, the Supreme Court said it's not all right to have all-white primaries. That's what the Supreme Court said in Smith versus Allwright. It's not all right to have all-white primaries. Okay, so even if it's a company-owned street, you've got public access, and primaries are run by the state since they run the elections. Those are both examples of state actions. The next case is Shelley versus Kramer. This has to do with the Supreme Court, excuse me, not the Supreme Court, any court, having to enforce a decision. If there's a contract that has a discriminatory provision in it, such as this property can only be sold to white people or cannot be sold to minorities. Well, that was the issue in Shelley versus Kramer. There was a racial discriminatory provision in the contract that restricted who could buy the property. Well, this is challenged, and the Supreme Court is going to argue, look, this is a contract that if it gets challenged by the courts, now you're asking the courts to have to enforce a discriminatory policy that's in this contract. Well, you can't require the courts to enforce discrimination. So this would entail state action because now you have state courts that would be required to enforce discrimination, and therefore that violates the Equal Protection Clause. So that's Shelley versus Kramer. That was discriminatory covenants or provisions that discriminated people based on race in the sale of property. That's unconstitutional. It's a state action because you can't require courts to enforce a discriminatory contract. Okay, the last three cases is significant state involvement test. Burton has to do with a parking authority, which is right next to a private restaurant. Is that enough to constitute state action, or can that private restaurant still discriminate? Supreme Court said, well, since it's a state-owned parking facility, you're going to have patrons that are going to be visiting that restaurant that have to use that parking facility. Therefore, that's a close enough state nexus, or they say nexus, connection. There's a close enough connection between a state action and a private restaurant. Therefore, that restaurant can't discriminate when it comes to serving people based on race only. So what did the Supreme Court say? There's a close enough connection or nexus between the state-owned parking facility and the private restaurant. Therefore, the restaurant cannot discriminate. That would violate the Equal Protection Clause. Because if you're going to be a patron there, you're going to have to use a parking facility. And who runs the parking facility? The state. All right, Moose Lodge versus Irvis. This is a case about a person who's a member of the Moose Lodge brings his friend in who happened to be a black American, and they refused to serve him. Well, this is a private club. So the question was, is there a state action here where this private club refuses to allow or refuses to serve a black American alcohol in this case? Well, the argument made by the patron was, look, they get their liquor license by the state, therefore not serving a black American would be discrimination that the state is endorsing. The Supreme Court disagreed with this. That's not a close enough connection. Then you'd have to say that anybody that has gas, electricity, or water that comes from the state, that would apply to state action as well. The Supreme Court said that's not a close enough connection. So therefore, in Moose Lodge, that private club was allowed to discriminate. Well, when I say allowed to discriminate, because they're in a state that allowed that kind of discrimination to exist. All right. All right. Next one, Norwood versus Harrison. What if a state provides public funds to private schools that are all white schools? Is that a close enough connection between a state and a private institution? Would that include state action? The Supreme Court said yes, because you cannot expect, or you cannot allow, I should say, a state to provide funding, in this case, it's funding for textbooks, to a racially discriminatory private school. That would be the state funding discrimination. So the Supreme Court said that was a close enough connection. So if you look at these significant state involvement tests, if the state is running the parking lot next to a restaurant, that's a close enough connection. If the state's providing textbooks to a private racially discriminatory school, that's a close enough connection, and therefore they can't be allowed. However, the fact that states issue liquor licenses, they provide water, gas, electricity services to private entities, that's not a close enough connection. So all these cases that I mentioned have to do with, does the Equal Protection Clause prevent discrimination by these entities? Well, there's got to be a close association or connection, which you might see the word nexus, between the state and that action. And in almost every one of these cases I mentioned, there wasn't a, in almost every case that I mentioned here, there was a close connection, and therefore the Supreme Court said that was in violation of the Equal Protection Clause. The only one listed here that's not a close connection was the Moose Lodge case. But I would argue the Civil Rights Act of 1964 would prevent Moose Lodge from being able to discriminate based on race to someone in their club. Why would I say that? Because the state that lodge is in would then not be eligible for federal funds because they're allowing discrimination to exist in their state. So that's how a lot of southern states were forced to start enforcing anti-discriminatory actions, because they're not going to get money from the federal government unless they prevent discrimination from existing based on the Civil Rights Act of 1964. Again, what's the whole point of these notes? These notes are meant to explain, when does the Equal Protection Clause prevent discrimination? Well, it's only going to apply to state actions. And there's got to be a close enough connection, or you'll hear the word nexus, to a state agent or a state institution. Otherwise, the Equal Protection Clause doesn't apply. What might apply today? Well, as I said previously, the Civil Rights Act. How so? Because Congress has tied funds, federal funds, to states, which they will not receive those funds unless they enforce anti-discriminatory policies. That's why this page is so confusing for most people, because it's really not much of an issue today, because most states will enforce anti-discriminatory policies. Because if they don't, they won't get the money.